former President Donald Trump and incumbent President Joe Biden will remain on Illinois' March 19th primary ballot. Welcome back, Bishop on Air. It's incredible to see this taking place, especially with states like Colorado and Maine, and now you got the U.S. Supreme Court getting involved. They're actually going to be hearing a case about this issue of whether or not Trump can be kept off a ballot because of alleged insurrection, something he has not been found guilty of. I don't even think he's been charged with it, with the 90-some-odd federal charges that his opponents say are going to be, the end of Trump. But we'll see. Either way, yesterday you had the hearing of the Illinois State Board of Elections, a bipartisan board, equal Democrat, equal Republican, who heard the hearing officer's recommendations, administrative judge recommendations on a whole host of ballot access questions, including the individuals who are challenging Trump's name on Illinois' primary ballots. And those challengers said, hey, Trump's an insurrectionist. He incited the insurrection on January 6, 2021, and it was a deadly insurrection. And they, even played video that was highly edited during one hearing last week. But yesterday, the State Board of Elections holding their official vote, and they had several things they could have voted for. They could have approved to kick Trump off the ballot, or they could have gone ahead and denied moving forward with such an objection. Jack Vrett, he is a State Board of Elections member, and he made this motion yesterday, spelling out how he says the Illinois State Board of Elections is very limited in what they are actually able to dip their feet into when it comes to ballot access issues.
It is a phrase in the law or an axiom that hard cases make bad law. And I think we can all agree that that applies to this case and the situation that lays before us. I think that the General Counsel has made a good job and tremendous effort into protecting the jurisdiction of this court, protecting our authority, and making sure that there is a record sufficient for the parties to fully litigate this matter upwards on appeal, as both have said that they intend to do regardless of the outcome today. So I commend the General Counsel for that. The General Counsel advises us that if we pass on the constitutional question, we would be exceeding our authority under the election code. And I think it's important to reflect on what that would mean for this board, specifically if we were to do so. If we exceeded our authority and went beyond the documents and the nominating petitions and looked at the underlying conduct that was alleged in this case, what I believe we would see is a opening of a floodgate of litigation, not necessarily before this board, but before all of the electoral boards that look to us for guidance on all the different election matters across the state. The fact is that this board sets the standard, the legal standard and the procedural standard for all the other electoral boards across the state. We're talking about the county elections, the village boards, school boards, and the like. And if we allowed them and gave them authority to say, don't just look at the papers, but actually look at underlying allegations of misconduct, that would open up floodgate. One of the things we've seen over the years in this board is that challenges in these local elections often are the fiercest of any contested case, more so than at the presidential level. And I think that what we would see if we exceeded our authority is every possible school board candidate would seek to challenge the qualifications based on some sort of alleged criminal conduct. And this board and the other electoral boards are certainly not constituted to do so. There was wisdom, I believe, in the legislature when they created the election code and said what our authority was, and by that, what our authority wasn't. And when we all took an oath to serve in this role, we would be violating that oath if we exceeded our authority and wade into the constitutional question against the recommendation of the hearing officer and against the recommendation of the General Counsel. I'd also note that in addition, so that the record is clear, I think that the relief that objectors are seeking is one of ballot forfeiture, and under our statute, they simply haven't presented a case for ballot forfeiture as well. So with all of those caveats in mind, that's the rationale in my mind. Maybe others have others, but I would move that we accept the General Counsel's recommendation that the candidate did not file a false statement of candidacy, insofar that there is some sort of statement necessary. I think that we do not have jurisdiction to weigh into the constitutional issue, and to decide the question of whether the candidate engaged in an insurrection in violation of Section 3. Therefore, I further move that we deny the motion for summary judgment, grant the motion to dismiss for lack of jurisdiction, and therefore overrule the objection.
So that is the motion that was made, and it was unanimous. They voted 8-0 to approve that motion, denying the motion to withdraw Trump's name and approving the motion to dismiss that objection, saying that they don't have the authority to say, well, a criminal allegation is grounds to remove somebody from the ballots. If they do that, they're going to open up a whole can of worms, even down to school board races, he said. So Jack Verrett there, the board member with the Illinois State Board of Elections, making that motion. So Trump's going to be on the ballots unless there's some kind of court action, because you've got the Illinois State Board of Elections that is just one body, right? So maybe those who wanted Trump off the ballot are going to take this to the courts, and maybe it's going to move its way through the courts. What about the U.S. Supreme Court and how they deal with all of this? So clearly there's going to be some more stories about this, depending on what various individuals do to either go to the courts and try to appeal the State Board of Elections decision here when it comes to Trump's name on the ballot. But you also had yesterday objections to try to get incumbent President Joe Biden off the ballot in Illinois. Those objections were thrown out as well. So Joe Biden's going to be on the ballot also. Our primary in Illinois is March 19th. So we have several more weeks to go here. We'll be watching to see what happens and how all this comes together. But what a fascinating time to be alive. No question about it. It is Bishop on Air. Be sure to like, subscribe, hit that notification bell, and follow along anywhere, especially on X. Just search Bishop on Air. You can also find me on Facebook, on Spotify, on Rumble, here on YouTube. Greatly appreciate you guys being here each and every weekday morning.